Hello, everyone, and welcome. My name is Professor Valerie Oosterveld, and I'm at Western Law. Professor Margaret Martin and I are part of Western Law's Public and Private International Law Research Group here at the law school, and we are very pleased to welcome you to this year's International Law and Global Justice Annual Lecture. Before we begin, I want to recognize that we are coming to you today from the traditional and very snowy territories of the Anishinaabe, Haudenosaunee, Lenapehouk, and Chinookan nations on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. And this land continues to be home to diverse Indigenous peoples who are vital contributors to our society. We are very pleased to be hosting Patricia Viseur Sellers today. Patricia is an international criminal lawyer with expertise in slavery crimes and gender-based violence in armed conflict. She is the former special advisor for slavery crimes to the prosecutor of the International Criminal Court and was instrumental in the creation and launch of the prosecutor's groundbreaking 2024 policy on slavery crimes. And previously, she also served as the prosecutor's special advisor for gender. Patricia teaches at the law faculty of the University of Oxford, where she's also a visiting fellow at Kellogg College and a fellow at the Bonnevero Human Rights Center. She also advises international organizations, governments, and non-governmental organizations on accountability for slave trade crimes, slavery crimes, and gender-based violence crimes, and serves as an expert witness before international, regional, and domestic courts on these topics. Patricia was the legal advisor for gender and a prosecutor at the International Criminal Tribunals for the former Yugoslavia and Rwanda. She developed legal strategies that led to landmark decisions regarding sexual violence as constitutive conduct of war crimes, crimes against humanity, genocide, torture, and enslavement under international criminal law. She served as a prosecutor and advised the trial teams in the Akayesu, Frunzia, Kunarach, Nikolic, Orich, and Stankovic cases. Patricia Sellers is the recipient of the prestigious Goler T. Butcher Medal and the Prominent Woman in International Law Award from the American Society of International Law. She holds an honorary doctorate in law from the City University of New York, as well as an honorary fellow for lifetime achievement from the Law School of the University of Pennsylvania, which is her alma mater. Patricia will be speaking to us today on the topic, the reemergence of slavery crimes. And before I turn over the floor to you, Patricia, I encourage all of you who are watching this to put any questions that occur to you into the Q&A button. Over to you now, Patricia.
Thank you very much, Professor Oosterveld, who I consider a long-term colleague and a friend. And thank you very much, all of you who have come to listen today or virtually. I understand that you've just gotten through a pretty bad snowstorm. So I hope that slavery crimes will warm you up a little bit, okay? I can't promise that I'll take off all the chill. But once again, thanks for the very warm introduction to Professor Oosterveld. And I'd like to also express my gratitude to Professor Margaret Martin and Western Law School of the University of Western Ontario for asking me to present this year's International Law and Global Justice Lecture. I'm humbled to speak to you this afternoon, as I'm quite aware that previous speakers are prominent international law scholars, some of whom I've had the privilege to call colleagues, such as Payam, and friends such as Leila Sadat. The reemergence of slavery crimes is the title of my presentation. And by slavery crimes, I refer to the international crimes of slavery or enslavement, the slave trade, and sexual slavery. These international crimes are also war crimes, more formally known as the violations of the law and customs of war, and likewise, they're crimes against humanity. Importantly, slavery crimes are peremptory norms. That means they're afforded the highest value under international law. Slavery crimes such as slavery and the slave trade are also non-derogable human rights violations. Therefore, I could say quite confidently that the prescription of slavery crimes and human rights violations sits at the apex of the international community's legal values. The reason I stress this is to say that at times there's a confusion. Well, what are slavery crimes? Are you really talking about trafficking? Oh, do you mean modern day slavery? Are you talking about child labor or forced labor? So I'm going to stick to some precise legal linguistic terminology today. And then as we go forward, and hopefully in the question and answers, we can compare my terminology to terminology that you might have heard that you might refer to as modern day slavery or similar institutions to slavery. So what I'd like to emphasize in the very beginning, and then I'll return to it, are the points that I call the reemergence of slavery crimes. And there are three particular points that I would like to pull out. First is the jurisprudence of various international judicial mechanisms that have tried slavery crimes within their case law. Those mechanisms are such as the International Criminal Tribunal for the former Yugoslavia, which tried the case of Kunaras and have brought forward the understanding that enslavement as a crime against humanity encompasses acts of sexual violence, as well as psychological, physical control, as well as really a type of ownership over what were basically a group of young women and girls, meaning people under 18 years old who were kept by Bosnian Serb forces in the former Yugoslavia. Another international judicial mechanism is a special court for Sierra Leone, which brought forward really groundbreaking jurisprudence on slavery crimes with the recognition that child soldiers, those children, are basically enslaved children, and that persons who were forced to work in the mines were enslaved, and that is why their labor was allowed to be subtracted from them. There's another judicial mechanism that's often overlooked, and that's the extraordinary chambers in the courts of Cambodia that also looked at slavery in the same time period in which the genocide committed by the Khmer Rouge was occurring. And then there's the International Criminal Court that has had several cases related to enslavement crimes that have really been groundbreaking. And I'll talk about Intaganda, which is a case that involved child soldiers, but where girls were sexually enslaved. And the court makes a finding that that sexual slavery, in addition to rape, is a jus cogent violation. In addition, there are national cases, such as in Guatemala and more recently in Germany and in Sweden. And I'll get to those. So this is one of the emerging moments in international criminal law via these international judicial mechanisms of slavery crimes. And of course, I'd like to add on that the release of the prosecutor's policy on slavery crimes, Prosecutor Khan of the International Criminal Court in December, is also a stellar moment because it's the first time that any judicial mechanism has seriously and consistently looked at slavery crimes under its mandate, and in this instance, the Rome Statute. Which leads me to the second reason that we're having a reemergence of slavery crimes right now. And it's because there's been a proposal to amend the Rome Statute, which is the governing statute of the International Criminal Court. And the proposal is to amend the statute to enumerate the slave trade as a crime against humanity and to enumerate slavery and the slave trade as war crimes. So for a judicial mechanism to step back and amend not a procedural part of its statute, but actually to amend the substantive crimes, as the Rome Statute did previously with aggression, is really a standout moment in international criminal law. The third reason that I say that there is the emergence or reemergence of slavery crimes, and perhaps the most significant, is that in 2029, there will be a full conference of UN member states to draft the proposed Crimes Against Humanity Treaty. That negotiation will be a negotiation that takes place only once every 25 years, every 50 years, every 100 years. This is the first time that there will be a treaty devoted to crimes against humanity. And one of the proposed inclusions in that treaty is the slave trade as a provision that will go along with the provision of enslavement. So these 3 points to me are quite important, if not preeminent, in terms of the reemergence of slavery crimes. However, let me digress just a little bit, because the reemergence of slavery crimes presupposes that there was already a historical existence of slavery crimes. So the first portion of this lecture, I'm going to highlight what were the historical slavery crimes, but I'm going to acknowledge that they themselves are somewhat submerged, and sometimes they have gauzy features, or we live in our mythology that unfortunately has been prompted either by Hollywood or prompted by, and I will be the first to admit, our own ignorance about the breadth of slavery and the depth of slavery crimes. But I posit that we egregiously ignore that breadth of past slavery crimes, and therefore our lack of knowledge makes us incapacitated and makes us remiss in discerning the scope of the present legal protection offered by slavery crimes under their preemptory norm status and the different aspects and institutions and practices of slavery crimes. Most of our knowledge with slavery in the Americas and the Caribbean derives from whatever familiarity we have with the transatlantic slave trade. That is the slave trade of Africans. However, this knowledge is usually truncated. It's replete with these gaps and distortions and myths. And some of the myths come from the formerly enslaved. A lot of the myths come from former enslavers. And a lot of the gaps come from persons who just did not seem to have been concerned either historically or in the present day. And I'm not making either excuses or verifications or justifications for any perspective or angle. My only point is it leaves us with a diminished perspective of what was the reality of this grouping of slavery crimes historically. Canada began the gradual abolition of its slavery in 1793, and then slavery was fully abolished in Canada and the rest of the British Empire in 1834. So one could say that that's almost 200 years ago. And not being a history scholar, and many of us are not, we realize that we rely on the retelling of stories that in and of themselves seem to become further and further from the source. In the transatlantic slave trade, the overwhelming majority of enslaved persons, 11 million out of the estimated 12 million, were traded to the Caribbean and to Brazil. Today, it's easy to understand that the majority African descent region of the world is Brazil. As a matter of fact, Brazil has more African descent people and is only second to the country of Nigeria, the most populous country in Africa. So we can see the impact and the effect that the slave trade had on Brazil. Also, we can look at the Caribbean and understand that it's a majority African descended composition of countries. And therefore, there is that very nagging legal reality that we have to acknowledge that the enslavement of Africans into the Caribbean and their descendants must have coincided with the genocide of the indigenous people. I'd like to also shake some of our notions and stereotypes. Our stereotype of cotton plantations should not be ignored, but they should be supplemented with enslaved labor in mines. One of the states of Brazil is called the General Mines, Minas Gerais. And why does it have that name? It has that name in particularly because of the richness of the earth through the mines that really came out due to the enslaved labor of Africans. And this is what enriched the coffers of the Portuguese royalty when they were at their height of not only exploration, but of colonization. Now, I myself, I've lived in Brazil, and many Brazilians like to remind us that when the Portuguese Empire fell, that the Portuguese royalty sought refuge in Brazil, and therefore the colony had to take care of the colonizer. But it has to be said that neither the colony nor the freely relieved colonizers in Brazil took care of the enslaved, because Brazilian slavery does not end until 1888. It is the last country in the Americas to abolish slavery. The first country, Haiti, abolished slavery in the late 1700s, 1794, and then finally 1804. And so it was the only country of majority African descendants that simultaneously abolished slavery and colonization. Another myth that we kind of dance around within the Americas is the indigenous enslavement. And one should know that in Bolivia, the mines of Potosi, once again back to mining, at one time was the world's silver center due to the quantity of silver that was extracted from the mines with indigenous enslaved labor that went to the haciendas, that went to the churches, that went to the castles of Spain. One other fact I'd like to bring out about slavery in the Americas, for example, is candomblé, voodoo, santeria, speaking in tongues. These are basically Western African originated religions that we see up and down the Americas. It's not only just the proof of the enslavement, but the proof that among the things that was assailed was the religious beliefs of persons, their rituals, their belief systems of the enslaved became part of what was diminished. However, it's little known that there was a significant population of West African Muslims who were enslaved in North and in South America. As a matter of fact, the largest slave revolt of the Americas was committed by the West African Muslim slaves. They were referred to, or now referred to, as the Malay. And there is a festival every year in Bahia, Brazil, that celebrates their rebellion, that celebrates the fact that they told the masters that we will not remain enslaved. It is against our religion to be enslaved, for the Muslim to enslave the Muslim. So what's very interesting is that the Brazilian enslavers in Bahia sent them back to Africa. They said, we can't have this rebellious Muslim population among our enslaved because they will foment dissent and they will create other rebellions. Brazil is famous for several slave revolts and communities. But let me switch right now to the East African slave trade, because that's little known. There were slave trading that existed between Africa and India, Africa and Iraq, Africa and the Sultans of Oman, African and the Ottoman Turk Empire. The East African slave trade lasted longer and enslaved more persons than the transatlantic trade. And we rarely ever understand that enslavement when we're talking about the legal abolition of slavery or the contents of slavery conventions. The abolition of slavery, as I said, in Brazil occurred in 1888, but the East African trade is not fully abolished until 1910. And the reason why is that many of the enslavers of Zanzibar wanted to prolong enslavement so that their concubines, who they said were just members of the family, wouldn't feel deserted. I don't think they were really asking the concubines this question. And then there's one last episode of enslavement, historical slavery, that I think is important to acknowledge. And this is the enslavement of Europeans. And this has practically been suppressed or romanticized under piracy. There was what is now referred to as raids or razzia of the Barbary pirates. But what did those Barbary pirates do? They slave traded. They had a slave trade that focused on seafaring populations and sea merchants among the European coast, everywhere from the Mediterranean, especially the island of Palermo, up to Ireland. So that is why at times today, you'll go to the seacoast of different countries within Europe, And you'll notice that they have these tiny watchtowers. And once when I was in Ibiza, lucky me, I saw this little watchtower and wondered, well, what is this doing here? Oh, and they said, that's in case the slave raiders come. So some of those towers have not been turned down. And so I started to research to ask how many Europeans were enslaved during the 1700s and 1800s, the Barbary pirates. And the answer is 1 million. So how have we suppressed this? How have we gazed over? How have we centered our slavery on something that happened a long time ago to other people? So the form, the practice, the geography of enslavement might differ, but I would like to bring us back legally to say that the core of the crime is immutable. It's the same. It's the indignity of ownership of one human being over another, or of a corporation, an entity of a state over a human being or collective humanity, human beings. Slavery was defined in the 1926 Slavery Convention, and the definition was repeated in the 1956 Supplementary Slavery Convention. The first convention was put out by the League of Nations. The second convention was drafted and placed out by the United Nations. And the definition of slavery is the exercise of any or all the powers attaching to the rights of ownership over a person. While this definition might seem intentionally vague, it is surprisingly accurate in its breadth because it picks up the entire inherent indignity of owning someone either legally de jure or via practice and custom de facto. And so all the different instances of types of enslavement or forms, whether it be sexual, whether it be working in a mine, whether it be agriculture, any facet of the being of the human being, let it be religion, let it be culture, let it be family, that can be part of how powers of ownership are exercised over persons. Enslavement is like the definition of torture. Torture's definition is the intentional infliction of severe bodily or mental suffering for designated purposes. You do not have to list out the different types of torture because, as the saying goes, one can never step ahead of the mind of the torturer. And I think that that, in some ways, is the absolute gem within the definition of enslavement. It doesn't list each act. It lists the inherent indignity itself of ownership, de jure or de facto. And so therefore, I would say, as we look at the re-emergence of slavery crimes, that we have to look at it through this wider lens and understand that it has packed up a multitude of practices, but it does not have to exhibit A, B, C, 3 practices, and then you're enslaved. Anyone who is in that indignified position is enslaved. I would like to say that the policy from the Office of the Prosecutor also wanted to break some of the myths of enslavement that have come into our misunderstanding, such as slavery and slavery crimes are not the equivalent of trafficking. Trafficking is a transnational crime that comes from a whole different international law genesis. That was basically a crime related to organized crime and related to transferring women across state or international lines for immoral purposes, i.e., what used to be called prostitution. Its origin was called the white slave trade in the beginning, and it is not related to either the transatlantic or the East African or the European Barbary pirate trade. The other misconception we have is that slavery can be put asunder by the consent of the enslaved. Well, there is no element in the crimes of enslavement that say that if the enslaved have consented, then the slavery no longer exists. Slavery, consent is immaterial to slavery. And then the other thing I would really want to stress is that slavery is a continuing crime. It is only over once all the attachment or the exercise of power of ownership is over. So therefore, one might be enslaved for a day, a week, a year, or a lifetime. And then the last thing is that there is no defense to slavery if you happen to like your capturer, fall in love with your capturer, have your capturer's child and like the child. It is not about the emotional effect of the enslaved. It really focuses on the acts of the perpetrator. So with this reemergence of slavery crimes, I'd like to pull out some parallels that we understand that it reemerges. Why? Well, I would say because it's been submerged, but it's never disappeared. And we can notice the frequency of slavery crimes and armed conflict. For example, in the Civil War in Sierra Leone, and the current Civil War or war, internationalized war now, in the Democratic Republic of Congo, within the fighting of the Caliphate in Syria, slavery crimes and armed conflict occur simultaneously frequently. Slavery crimes often structure the nature of armed conflict. And one can certainly see that with the situation of Yazidis. One could see that with the slave labor that went on in World War II, both in the European theater and in the Asia theater. Slavery crimes also coincide, unfortunately, with genocide. I've mentioned the Caribbean before, but when one looks at the ISIS and the Caliphate in Syria, we see slavery crimes coinciding with genocide. When one looks at the Khmer Rouge action, once again, we have slavery coinciding with genocide. Slavery crimes often coincide with enforced disappearances. In Syria today, the detention centers that are now finally being shown some possibility, possibly of judicial redress, we note that enforced disappearance became routine. And we have to ask ourselves, as I have asked a former inmate, well, was there a time period during your detention that you felt you were enslaved? He says, yes, as soon as I was out of contact with my family and no one knew where I was being owned by someone. I was enforcedly disappeared, but I was enslaved. We never put those two crimes together, but I think their frequency is quite telling in situations, in particularly of police states. There is also the simultaneous occurring of slavery and sexual control through commission and omission. Most of the persons who have experienced forced marriage are enslaved persons, whether it be in the Cambodia situation, but also we've seen that in Sierra Leone. We have seen that in the Democratic Republic of Congo. We understand that exercising powers via sexual control, which might be control that you are not allowed to engage in sexual acts, is a manifestation of slavery. And then the other thing that we see slavery crimes coinciding with is children. Children have always been one of the targets of enslavement because they're malleable, but also because many are born into enslavement. And we can see that in a recent case that came out this week in Sweden that talked about children who were infants, who were enslaved because they were with their Yazidi mother. We know that in the Ongwen case in the International Criminal Court, that we had children who were born by enslaved mothers. There has not been a finding yet because of the prosecution's submissions to not reach that issue, but in the upcoming case of Coney, the submission will be that the children born of enslaved mothers who remain under the LRA are enslaved children. But slavery in children have a long history. When one thinks about those who were transported in the slave trade, transatlantic or East African slave trade, all of those persons who were subsequently born enslaved were first infants who were enslaved, children who were enslaved, until they became teenagers, older adolescents, and then adults. So the reemergence of our legal consciousness is what is more important now, so that we can put facts together with the legal definition, in particularly of slavery. Now that definition has to be inserted within the Rome Statute so that slavery can be a war crime, in addition to slave trade. To have left that out is almost unthinkable. I don't know, and I go back and forth to say, was it accidental or was it psychologically untenable? How could we have left out that war crime of slavery, when slavery and war go so often, so frequently together. When I look at the slave trade, and I haven't gone into the definition of slave trade purposely, but I see how that has not been included up until now within the International Law Commission's proposal for the Crimes Against Humanity statute. I'm wondering, is it because that we have really substituted the transnational crime in our mind of trafficking for the international use cogent peremptory norm of slave trading? And then I would just like to leave you with two thoughts. And one is a thought that you can see I weave throughout this lecture is, why do we have the hesitancy to look slavery, the enslaved, directly in the eye and remember, as opposed to forgetting, when we have the legal tools that have been honed supposedly at their highest level? Other than torture, it is rare that we have a provision under international law, but international criminal law, that comes with the peremptory norm status, which makes it the states have obligations under both human rights, but also under criminal law. How can we have such a strong legal weapon or tool and such a weak approach to the facts and to the situations of slavery crimes? And then the second thing I would like to ask, and slightly provocative, if we look at situations and we have to almost prompt ourselves to at least ask the question, then this is a question I might want to ask you at Western law. In the Americas, also in Australia, we know that Canada, the United States, have set up systems of schools for Indigenous children that were taken from their parents. And some of those children, in essence, disappeared. And some of those children, in essence, lost their life. But we know that those children lost identities, names, religions, family, relationships. We've seen that in Australia in the Lost Generation. We've seen that in the United States. I'm from Philadelphia, don't live very far from the Carlisle school system, and we've seen that in Canada. Could we dare to ask ourselves during this reemergence of slavery crimes, of whether those children were also enslaved, in addition to the other harms that occurred? Would this use cogent crime be a way of framing and fully characterizing some of their harms? How and why does slavery subside, submerge, and then sometime reemerge? We're at a pivotal moment. I think that we should take this reemergence and we should fully use it. And that's what I would ask you to do today. But of course, I'm open for any questions on what I've proposed or hinted at. Thank you very much.
Thank you so very much, Patty. Let me just remove the spotlight here. I have in the audience, Kate Karicki, you've raised your hand. I don't know if you're able to unmute and ask. You can try, but for everyone, you can also put your question in the Q&A button below. I don't think it's set up for Kate to unmute, so I apologize for that. But Kate, okay, let's see. Oh, you wanted to clap. Wonderful. All right. So please, anyone, put your questions in the Q&A below, Q&A button below. I will start, Patty, with a question for you, which is, you mentioned that we're at a moment in international criminal law with respect to slavery crimes, with the drafting of the Crimes Against Humanity Convention, which will hopefully be adopted in 2029. And with this proposal, I think it's by Sierra Leone, if I remember correctly, to amend the Rome Statute. Could you talk a little bit about the process? So is the slave trade already in either of these? I'm taking because I know some students are listening, they may not know. And
Mhm.
what is the process to get it in?
Okay, well, let me start with the Rome Statute, which is the governing statute of the International Criminal Court. And the Rome Statute, as we know, it covers war crimes, crimes against humanity, genocide, and it covers aggression for certain states. Under the war crimes provision, it's the longest list of war crimes we've ever seen at any international court or tribunal. And they're war crimes for international armed conflict, for non-international armed conflict, and for this category of within the framework of international law. But under that very, very long list, there are provisions, two provisions for sexual slavery, and there are no provisions for slavery or the slave trade. And that's something that caught my mind and some of my colleagues. Um, what was the backup charge for sexual slavery? Why didn't they also charge slavery? And as we went through it, there's no slavery charge and there's no slave trade charge. So the two crimes that were specifically placed in the 1926 Slavery Convention and the 1956 Slavery Convention, and that the International Committee of the Red Cross have designated as customary based war crimes, were not in the Rome Statute. And I think because of this, Sierra Leone, in discussing this, decided that they would propose an amendment. And at that time, understanding that there was no provision for slave trade under crimes against humanity either, they proposed, let's amend the Rome Statute so that the slavery crimes could be fully represented, both as a crime against humanity, add on the slave trade, and slavery and the slave trade under war crimes. So what they had to do was bring this to the working group on amendments. The working group on amendments discussed this, and then there's a procedure, it's a little quirky under the Rome Statute, that you have to take it to the United Nations. And in some ways, that's a pro form. So the United Nations had to officially receive a copy of the proposed amendment. They had to translate it into the different languages, and then it went back to the working group on amendments, where it is now. And it will probably be voted upon by the Assembly of State Parties at the next annual meeting in December of the Assembly of State Parties. But in the meantime, there have been many discussions with many of the members of the Assembly of State Parties, and their reaction has been basically, how did we not know that those two crimes were not war crimes? And the discussion in terms of the slave trade as a crime against humanity is one that kind of relates very much to the upcoming Crimes Against Humanity Treaty. And I would say right now, Valerie, that as you know, the International Law Commission is the one who did the first draft of the Crimes Against Humanity Treaty. And during that time period, I think there was quite a bit of advocacy, and particularly by feminist advocates, to look at that International Law Commission draft and make suggestions. At that time, suggestion was made to place the slave trade within that treaty, and the International Law Commission did not accept that suggestion. But there's been continued advocacy on that point. And now there seems to be a bit of a turning point because Sierra Leone and other states, and particularly the African states, but also many of the Latin American states, really want to see the slave trade included in the Crimes Against Humanity Treaty. So that's where we are right now. We've got about a year before the Rome Statute possibly might be amended, and a 4-year run-up before the final drafting of the Crimes Against Humanity Treaty.
Excellent. Thanks so much. Before I turn to look in the Q&A, Professor Martin, did you have any questions?
Yes, thank you for that excellent talk, Professor Sellers. I was wondering where the action is in terms of the negotiations of the definition, because I see an issue if it's very open-ended and subjective. And if you're thinking about prison, you might end up casting certain practices in domestic states in a poor light, and certain states might want to resist that reflected problem. So are there kind of difficult negotiations ahead in light
Well,
of?
I don't think they'll be that difficult for the following reason, is that this definition from the 1926 convention will be 100 years old next year. And the supplementary convention comes out in 1956. And I think it's fairly well understood that there's a difference between imprisonment and detention when it's illegal, meaning when a person who is detained does not have access to a lawyer, does not have access to their family, does not have access to humane treatment. That's very different. But I think the point that I was trying to emphasize, that there are certain situations of detention or imprisonment that are no longer detention or imprisonment. They're enforced disappearance and or they could be enslavement. So I don't think any state would say my detention is basically enforced disappearance. So that conversation doesn't arise at that time, but there might be some gray areas.
Can you talk to us a little bit about, so you mentioned that sometimes the term trafficking is assumed to cover what you are arguing for, the slave trade being added into the Rome Statute of the International Criminal Court and the Crimes Against Humanity Convention, the draft convention. Can you talk a little bit about that assumption and whether you think that will cause any problems as the discussions go forward for both of these treaties?
Right. But that's a very good question because many of us, I mean, from a layperson's sense, we hear more about trafficking than slave trading. And when one raises an issue of slave trading, they say, oh, do you mean trafficking? So what is trafficking? Trafficking is a transnational crime, not an international crime. And that means it's a crime that the states, different countries agree to cooperate with each other about. And trafficking comes out of the Palermo Protocol now. And trafficking is taking a means of reducing someone through an abusive means to a situation of exploitation. And so you might be trafficked for sexual slavery. The exploitation might be sexual, it might be enslavement. But what you have to prove with trafficking is that there was a means of some way of transport, and that within those means there was an abusive situation, and that situation led to an exploitation. Those are very different things than you have to prove with slavery or the slave trade. And if you're an adult, you might be able to say that I consented and therefore trafficking didn't happen. Under enslavement, it's immaterial whether the enslaved consents or not, because what the policy is to go after the accused who want to exercise powers of ownership. For trafficking, only if you're a child can consent be immaterial. And the other thing is that trafficking looks at slavery as a form of exploitation, meaning someone has to receive some type of benefit or good from the slavery, the slave trade. Under slavery and slave trade, under the treaty law and the customary law, the enslaver doesn't have to receive anything. They could have you be in a corner for 10 years. It's not about the benefit to the enslaver, it's about the inherent indignity of ownership over the enslaved that the enslaver is intentionally doing. So those are different crimes, but from a survivor's point of view, it's very possible that slavery, slave trading, and trafficking are happening simultaneously, depending on what evidence you have. And so you want to keep all of those jurisdictional venues or possibilities open for survivors. And so that's among the reasons that one of the things I've been engaged in the past 2 years is really having concerted conversations between the slavery crimes community and the trafficking community, so that we can reach some type of harmonization where the survivor benefits, so that they can have redress in a state court, or that they can have redress for their slavery crimes in international courts or state courts. So I think that we have to really loosen our either or and kind of approach it with what's best for the survivor. How do we make these different legal frameworks work to eradicate slavery crimes and trafficking?
That makes sense. Accountability in different venues, but for different things, even if they're if they're interrelated. So we have some good questions in the Q&A. Let me start with one from a law student here, Sarah. She says, as cyber slavery has emerged as a pressing global issue, do you believe it fits within existing and developing legal definitions of slavery, or does its digital nature require new legal frameworks to effectively address and prosecute these crimes?
Well, I think it's an excellent question. Right now, the legal framework we have, I believe, can address this. Maybe legal frameworks will be improved in the future. But what often happens with the cyber aspects of slavery crimes is they're using a different tool or mechanism, cyber, to reach and to exercise powers of ownership, whether it be with saying that I will put certain photos on the internet, I will have people contacting you. You have a form of blackmail, which is controlling your sexuality, controlling you psychologically, controlling your relationship now with families. So it goes to, as I was saying, the immutable core of slavery crime is the indignity of someone exercising those powers of ownership over you. The means by which they do it, that might change. The means have already changed over the 100 years and 150 years. So it's very, I think, important for us to look at the core of the crime and see how we can even apply it today.
Thank you. We have another question. This one is from Kate. And in essence, she's asking whether situations in which bodies, so this could be prisons or governments or corporations, pay unlivable wages in the context of no alternatives. Does that fit the definition of slavery, or would that fall outside?
Well, that would be on a factual determination. And here is, I think, we're approaching one of those gray areas. So, for example, if you pay an enslaved person, does that mean they're no longer enslaved? No, there's nothing in the Slavery Convention that says, well, once you're paid, you're not enslaved. As a matter of fact, there was a huge debate in the 1920s when they started to bring out the slavery conventions because colonialization was occurring. And colonialization would try and differentiate itself from historical slavery by saying we're offering a wage. And that's why the International Labor Organization started the forced labor conventions to say, well, you're offering a wage, but there's still something wrong with this. Okay, so we're going to call it forced labor. So if you have someone in a situation, let's say the company town is maintaining that and symbolically paying them wages that in no way respond to their daily living, but also that situation is really one of ownership, then you have a situation of enslavement. Let's just flip it the other way. An enslaved person can be well-dressed. As a matter of fact, there used to be enslavers who liked to dress up their slaves and put jewelry on them to show, look how rich I am. So it's not necessarily about the material goods you have or you don't have. One has to really look and see, what is that perpetrator doing to the person or persons?
So may I follow up with the portion of Michael Stozer's question? It's a long question, but just to follow up on that question, are there labor practices that corporations around the world might be participating in that don't look exactly like the definition, but might lean towards that definition, or we might begin to think of them as problematic? And is any attention being directed towards those practices?
Well, it's an easy question. Yes, that's the answer is yes. But let me elaborate a bit. For example, we'll see corporations, and I've looked at this in some of my research, that will talk about their child labor practices. And they say we make sure that we don't have any forced labor. Well, when you look under the International Labor Organization conventions in labor for children, and let's say in the chocolate industry in Ghana, we know that those are situations not only of child labor, of forced child labor, but of enslavement, if one lays out the factual basis. And seeking the venue to bring the case might be an issue, but remember, this is an international crime. It's a non-derogable human rights violation. But the extent to which certain persons in the chocolate industry, and I live in Belgium, we love chocolate, go to hide the labor of children speaks a lot about the fact that these are enslaved children working those plantations. So I think that in today's world, if we can understand the frequency of child slavery historically, we would not be so shocked and saying, well, what do you think? Could it be? And the other thing is that you see these corporations often trying to say, well, we're providing education. Well, you're allowed to educate your slave. That doesn't necessarily eliminate the enslavement. So we have to really practice how we understand what I'm trying to say is that we have to exercise our mind with the facts and the law, that we often see slavery right in front of us, and we refuse to see it, or we don't know how to see it because of our inability to have understood historical slavery.
Thanks. There's one other aspect to the question that Michael also asked, and that is, in essence, do you think that slave trading was left out of the Rome Statute, or slavery was left out of the war crimes provisions because of governmental interests in keeping it out? Have you come across any evidence in that respect?
Well, I don't have any conspiracy theories on that, but I do think that when you look at the definition of enslavement under the Rome Statute, you will see that there's one part that refers to trafficking in women and children. And I think some delegates might have thought, oh, trafficking's there, therefore we don't have to worry about slave trade, and not understanding that enslavement is different from slave trade, and that enslavement and slave trade is different from trafficking. So some of the discussions I've had with different Assembly State Party members has been around that issue. But there is a pull in some circles to say slave trading, it's abhorrent. Some people just don't like pronouncing that word. It's kind of like ooh, that's a bad crime. It gives me a bad feel, which is probably a good reason to put it in the statute then, because it's occurring. And we know that trafficking doesn't pick up all of the criminal activity that slave trading would. And I'll give a very quick example. Under slave trading, you can be slave traded 10 times, and each of the 10 slave traders could be accused of slave trading. And then only at time 11 are you reduced to enslavement. With trafficking, you have to be placed in that situation of exploitation where everything else in front of it falls. So when you think of the migrants going through Libya, they're often slave traded 5, 6, 8 times before they even get to situations of enslavement, because there's a network of slave traders that sometimes are called traffickers or smugglers. And so the slave trade would pick up each of those illegal acts and not have to wait for the exploitation to occur. When states start to understand that, then from my point of view, they start to process and they start to see that, okay, we have a different legal regime because it has a different policy basis of what it's trying to prevent. Conspiracy, not quite there, but the more we willfully remain ignorant, the more it could slip to that side too.
And I'll add one more insight to what you've just said, in that many of the people who were negotiating the International Criminal Court Statute in 1998 were representatives of the militaries of their own country.
Mm.
They weren't necessarily thinking in human rights terms or in public international law terms. Rather, they're thinking in law of war terms. And I found when I was there that that shaped and changed how some of the conversations went. So I'll just put that out there, because some of the students on this call, on this Zoom, are from my capstone in international law class, where we look at the people, the processes, and the structures of the making of international law. And the people are often forgotten.
I really think you're right on that, Professor Ostfeld. Although when I do speak to some of the military who've had that reaction, and I myself am a military brat, is that I go back to the Lieber Code. And the Lieber Code is one of the leading instruments in international humanitarian law from 1865. And it is among the few codes that was really a command to the Union forces in the United States that state that slavery and slave trading will be war crimes. And so kind of bringing the military back to its own origins of what they say was customary law moves that conversation along pretty quickly.
That's really, really interesting. So
Professor
may I ask, yes, you mentioned in the Lord's Resistance Army and Joseph Kony, when you're dealing with individuals like that who were once themselves slaves and then they become the people that are enslaving others, how do you navigate that difficult moral issue because on the one hand, they are the most culpable, and on the other hand, one can see why they behave as they do because they themselves were part of the or on the other side of the issue initially.
Yeah, so it's an excellent question. You can see in Ongwen that that's taken into consideration in the sentencing, but that certainly didn't obviate their intent to enslave. And then one has to understand, very quickly that that enslavement system of the LRA is a system and one is socialized, one grows up in, and then one gets power so that they finally themselves can become the enslaver and not the enslaved. It is very complicated, but at the same time, at a certain adult level, there was complete knowledge of the system and complete knowledge that he was slave trading and enslaving others. So I think it did, and it should have gone to the mitigation of the sentence. And it's a crime, and we weren't in the human rights jurisdiction.
Can I ask one last question, Patty? And that is, you had mentioned the example of Libya. So many people are being channeled through Libya. And you were explaining how it's slave trading and slave trading and slave trading and slave trading, one after another there. In the International Criminal Court prosecutor's charges with respect to this, how did he deal with that since the slave trade is not in the statute?
Well, I think how he dealt with it in the Ongwen case is quite telling, because in the Ongwen case, very much they understood what was called abduction and kidnapping, reducing someone to situation or the status of a slave, is slave trading. But since he didn't have the provision for slave trading there, the prosecutor went the further step to prove that they were exercising powers of ownership when they did the kidnapping and the abducting. And just as important as that, when those persons, both adult and children at that point in time, were enslaved, and then the boy children became child soldiers, and some of the girls who matured, physically matured, became sexual slaves or forced marriage, then that slave trading of assigning them to a different group or assigning them to a husband, he also couched that under an act of enslavement, of exercising powers of ownership. And I think that was the best thing to do with the statute as it is, but they had to prove an even higher level than they would have in terms of the evidence that would have been necessary for slave trading.
Thank you. I see we have come to the end of our hour, and I'll turn it over to Professor Martin.
Hi, so thank you, Professor Sellers, for joining us today on behalf of Western and on behalf of Valerie and myself and all of the participants and the audience today. We'd like to extend our gratitude to you for making time for us. So that was an excellent talk, and thank you.
Thank you very much for having me, and I wish everyone a good afternoon. It's evening time here in Brussels. And if you are interested in any other questions related to slavery, please, either through Professor Martin or Professor Oosterveld, get in touch with me. Thank you very much.